Welcome back to the second part of opinions of third persons when they are relevant. We were discussing from section 45 to 47, wherein we came to know that opinions of third persons when and how they will become relevant before the court of law. Uh, 48 section deals with opinion as to existence of right or custom when it is relevant. Section is very simple and very small. It only deals with when the court has to form an opinion as to the existence of any general custom or right. At that time, the opinions as to the existence of such custom or right of persons who would be likely to know its existence if it existed are relevant. It is very simple that whenever there is a question has arisen before the court with regard to forming of an opinion whether a particular right or custom is existed or not existed, then court has to rely upon the opinions of such persons who would likely to know if it is existed. Means if that right or custom is existed, some people are likely to know that and their opinion is relevant opinion. There is an explanation with regard to the expression general custom or right. It includes the customs or rights common to any considerable class of persons. So here considerable class of persons may be a particular village or a taluka or a district, or maybe a particular religious community or a particular group of people who are called with a specific name of caste. Like this, several different types of group of people we are looking into the social classification in Indian society. Each such group of people can have their own separate customs who are general, which are general to that particular group of persons. Such customs or rights, if they are in question, in that case, courts may rely upon such experts who are likely to know the existence of such customs. There is a small illustration with regard to whether the right of a particular villagers to have water from a specific well is existed or not existed. It depends upon the opinion of seniorly or elderly people of that village who have seen the entire village using the water from that particular well. That is how their opinion can become relevant in order to establish whether the entire public of the village has got that general right or not. This is how section 48 explains. Now section 49, it says that opinions as to usages, tenets, etc. when relevant. Now, it is not custom, keep in mind. There is a difference between custom and usage, what we have already studied in the previous classes. Here, the question is with regard to opinions as to usages, tenets, etc. It says that when they are relevant. When the court has to form an opinion as to the usages and tenets of any body of men or a particular family, or sometimes with regard to constitution and government of any religious or charitable foundation. Here government means only administration you have to take. You should not understand in a manner of central or state government. Here only question may be with regard to how this is constituted, a religious or charitable trust or foundation, how it is run or administered, if that question is arising. Next, or the meaning of a particular word or terms used in a particular district, if the question arises with regard to what is the exact meaning of this word so and so in that particular district, then also it comes under section 49 only. Or by particular class of people, means some words which are used in some particular class of people in a different manner. The opinions of persons having special means of knowledge thereon are relevant facts. Now, we can say that, especially in Karnataka, we have got different types of Kannada again. Almost 29 to 30 districts which we have, they are not speaking the Kannada in a similar accent. Even the words, vocabulary from one district to another district, from one part to another part is completely different. If we see the Kannada of Mumbai, Karnataka, Hyderabad, Karnataka, Mysore, Karnataka, Mangalore, Karnataka, all these four different parts of Karnataka, they have got specific different words to be used in that only particular area. Such words will be construed in their particular meaning which is assigned in that particular area only. We can seek several examples like this. If in North Karnataka, if you ask the meaning of word tindi, it is nothing but a person's intention to fight with somebody. But in South Karnataka, tindi means breakfast. How detrimentally same word has got two different meanings in a similar language. This is how we cannot construe the words in general unless we have a specific application of interpretation from that particular district itself. That's why section 49, it plays very vital role in order to construe some particular words or even to find out whether the particular usage or usage or tenet is existed in that family or not. We have seen during the marriages several customs, several different types of usages, traditions are followed for almost 4 to 5 days, 10 days, like this marriages will be conducted in India. From where we can see the differences of usages and differences of tradition from one family to another family. Sometimes groom's family telling that it is not there in our family, we cannot do that. Sometimes bride's family is telling that no, it is compulsory in our family, we have to follow this tradition, then only marriage is accomplished. Like this, there will be difference of traditions and usages from one family to another family in the same caste, in the same religion. That is possible only in India. This is the beauty of India. That's why we call it as entire world is there in India itself because of its multicultural, linguistic and multi religious culture which is there in India. The next section is section 50, which deals with opinion on relationship when relevant. It is very crucial when the court has to form an opinion as to the relationship of one person to another. The opinion expressed by the conduct of such parties as to the existence of such relationship is important, or any person who as a member of that family or otherwise has a special means of knowledge on the subject is relevant. Here, in order to find out whether a relationship is existed between these two people who are in question before the court, we can find out such relationship from two different evidences. One is from their own conduct, if how their conduct is, in what manner it is suggesting, how they are behaving with each other, that is important. Second one is with regard to the opinion of the same family's one person who has got special knowledge of their relationship, that person also can give his opinion. So here section 50 says that the opinion of a third person in order to establish the relationship between one person to another person is relevant under section 50. But there is a provision in this, provided that such opinion shall not be sufficient to prove a marriage in proceedings under Indian Divorce Act 1869 or in prosecutions under IPC sections 494, 495, 497 and 498 of the Penal Code. Here it is very clear that only in order to establish the relationship this section 50 is playing the role. But in case of divorce proceedings and in case of criminal prosecution with regard to 494, 495, 497 and 498, this section 50's evidence is not sufficient. That means it can be used as an evidence, but it is not sufficient. You must have to bring corroborative evidence along with this. Then only it is necessary to place before the court. We can use a small example here that if two people, that is one male and one female, are living in a society as husband and wife, and the people who are surrounding to their house, means their neighbors, they have seen these people acting as husband and wife. And also whenever they are visiting some general parties of their relatives, of their friends, in those family parties or relatives parties, they are pretending as husband and wife only. Whether they are married or not married, their conduct can be placed before the court of law telling that they are husband and wife. Like this, section 50, it is relevant with regard to opinions in order to establish the relationship between two or more persons. Whenever there is a contradiction in evidence of relationship of witness, the triple nature not material in a particular suit is actually held in Gohari Das versus Shantilal Singh. In this case, AR 1999, Orissa 61, it was held that contradictions, if there are in evidences of relationship, if there are two different types of opinions are coming from the same family, then it cannot be relied upon in a partition suit. It is only with regard to partition suit when, if the relationship between the defendant and plaintiff is in question, then contradicting opinions cannot be accepted. Both the opinions will be rejected by the court. Thereafter, the last section of this chapter, this particular discussion is section 51. It speaks about grounds of opinion when they are relevant. It's very simple. Whenever there is opinion of expert is relevant, then 100% such grounds on which the experts have come to such opinion also relevant. Without the grounds, opinion is meaningless, and without the meaning, grounds are meaningless. That's why grounds are also relevant in order to establish the opinion, whether it is genuine or not, whether it is subjected to the further verification by the court or not. It is completely depending upon the grounds on which the opinion was formed. Thank you so much.